Good morning, sir. Myself, Devdhar Dubey. I belong to LLB Honors, Semester 8, Section B. My topic for the assignment is Central Civil Services Pension Rules 2021 with a special reference to right to information. In this, we will try to analyze the conflicting provision of Central Civil Services Pension Rules with right to information. Basically, there are two conflicting interests. One is that of the government, and the other one is that of an ordinary person who is trying to get information from the government. If I brief you about the recent development which took place on 31st May 2021, where the Department of Personnel and Training has notified an amendment to the Central Civil Services Pension Rules, where Rule 8 stands amended and subclause 3 has been added. As per the newly added provision of Rule 8 subclause 3, all the retired officials belonging to security organization or intelligence department shall have to take prior consent, prior approval from the concerned organization in case of making any publication of any writing that is related directly or indirectly to the concerned organization. So, by this amendment, a mandatory provision has been incorporated that a consent, a prior approval has to be taken before such publication. In this, they have to submit their document to the concerned organization, the head of the organization, where after a proper review, he may allow, he may refuse such publication. In case if such person do not follow this rule and publish the document without such approval, then in that case, government can make him liable under the relevant provisions of law, and also central government has power to deprive him the pension benefits which he is entitled under this Central Civil Services Pension Rules. However, there already exists a certain legal provision similar to this under Rule 8. Rule 8 mandates that the good conduct of such retired government officials shall be implied, and in case if they are found guilty of any serious criminal offence or if they are found guilty of any grave misconduct, then their pension benefit may be seized and they may be deprived of their pension benefit. Here, grave misconduct includes the disclosure of official secrets. So, despite of being having such an stringent provision, the government has brought these new amendments. This led the public to criticism that government is trying to over-regulate these government officials and thus restricting their freedom of speech and expression, and also affecting the right to information of the general public, as this information may be helpful to the general public as well. So, moving ahead to our next part, that is right to information. Basically, after the Supreme Court judgment declaring right to know being a fundamental right, the Parliament of India has enacted the law named as Freedom of Information Act 2002, which was later replaced by Right to Information Act 2005. As the name suggests, it provides for the right to the citizen for obtaining information which are under the control of any public authority or the government. So, Section 3 of this Right to Information Act provides that every citizen has right to access those information that are under the control of government or the public authority. But these rights are not absolute and are subject to the limitation or restriction imposed under Section 8 or Section 9. Section 8 provides for certain provisions where such information can be denied by the public authority and can be refused by the public authority, and Section 9 provides that if such information may violate the Copyright Act, then such information may be refused by the public authority. So, if we try to interlink all these new concepts, the new amendments brought under the CCS pension rule, the right to information and other legal provisions, there may arise certain conflict of rights. For example, if a concerned person wants to access more about a security organization and he wants to access certain information that are under the control of security organization or the government as such, then the government or that concerned organization is going to refuse such information to the concerned person on the ground of national security, unity and integrity of India. And such refusal is wholly justified, and we all support that refusal. And the government of India must protect such information that may affect the national security and integrity. But if the very nature of such information is that it would have hardly any implications on the security or national unity of India, but are under the control of such organization or the government, then also the government is going to refuse such information. There arises the question that the government must disclose such information to the public, otherwise the whole idea of right to information is no fruitful at all. So there arises the conflict of right, and if we consider the new amendments brought under the CCS pension rule, then such restriction is more enhanced and the access to information of public is much reduced. For the purpose of better understanding, we must know the categories of documents that are held by these security organizations. Basically, there are two types of documents that are classified and not open to the public. First one is such classified document that still needs protection, and in case of its disclosure, it may seriously hamper the national security. So these documents must be classified and must be kept secret. But the other category of document that is classified but needs no protection at all and may be declassified, as it would not hamper the national security. So India, to counterbalance the national security as well as right of freedom, it may adopt a middle path by adopting the declassification policy as already implemented in the USA successfully. Basically, declassification policy provides that any information that is confidential, that is classified by the government, can be declassified or can be thrown open to the public for some period of time after a proper review has been made to such document, and after making ensured that these documents are not going to hamper the national security or integrity of India at all. So these documents that are earlier being classified can be thrown open to the public via National Archive of India. So India must adopt such declassification policy just like USA. After receiving several criticism, the Ministry of Defence has recently announced on 17 June 2021 that they are going to adopt a limited declassification policy. Basically, they are going to declassify such document that relates to the war records or that relates to the operation records conducted by the security personnel. Basically, for this purpose, they are going to make some committees which will review such records, and after making ensure that these records will not be going to affect any way the national security or integrity of India, they will be thrown open to the public via National Archive of India. Basically, through this step, the Ministry of Defence is trying to balance these conflicting rights and trying to ensure that every citizen have right to access as much as possible information, and the government must minimize the content of the information that are protected under the Official Secret Act, and such information should be protected only when if it is required. Basically, this declassification policy is of two levels. One is full declassification policy, in which all such war records or operation records will be declassified to the open and thrown open to the public, and the other category of document are such that it will be partial declassification and will be used for only internal consumption and will not be open to the public at all. So this declassification policy is a landmark decision taken by the Ministry of Defence in the line just like USA. So we can conclude that the declassification policy is the way forward, and India should declassify all such irrelevant documents that are still being classified and have no serious implications on the national security and integrity of India. This will ensure that there is a proper balance between the right to information and national security. However, while declassification, India must be little conscious about the process adopted by the review committees, because in case of any mistake made by these review committees, then it may be that this declassification policy proved to be disastrous and it would have serious implications on national security and integrity of India. So the proper review process must be ensured, and such document before making it public must be checked thrice or as much as possible to ensure that there will have no serious implications on national security and integrity, and will definitely balance the right to information as well. Thank you. This is all from myself. Thank you, sir.